Get through.
Is it unmuted?
She's still getting her stuff up there. Okay, I think we're live now, looks like. Okay. We are now coming out of closed section. And we are back in open meeting format, so we're streaming live on YouTube, as well as recording the session. I'll summarize and then I'll let, and on the phone, I have the ARB counsel, Judy Hargrove, is on the phone with us. And she will step in as required, either by questions that we ask, or if she hears something that needs to be addressed. Okay. What we spent the last period of time discussing with Judy was the questions revolving around the late protests dealing with tax years 2019 and 2020, recognizing that the request for protest for 2021 was filed timely in terms of meeting dates and deadlines. However, it's our belief, and I think our counsel backs us up, that the request for granting a hearing for 2019 and 2020 should not be allowed, because even though a request for application may be allowed, that does not override any deadlines associated with filing a protest or a request for a late hearing. At this point, unless somebody objects, I'd like to hear from, and I'm sorry,
Dominic.
Dominic, okay, who is the property owners council, is that correct?
Yes, sir.
Okay. To make a few comments which might address and support or not the granting of the late protests dealing with 2019 and 2020. Okay. I think, and as part of your discussion, one of the things from the ARB is just the overriding question of what rationale or what reasons did exist why timely protests were not filed for 2019 and 2020. Anybody got any? Okay, so Dominic, I'll leave you to talk for a minute or two.
Thank you. Thank you. So going back to 2018, I placed the district on notice via a request for a predetermination of tax exemption. I sent an elaborate letter to the chief appraiser in June of 2018, I believe, asking, indicating what would be the structure of this deal. Indicating we hadn't even taken title to the property yet. This is about 6 months before we even took title to the property. I sent a request saying, on a pre basis, on a pre-purchase basis, can you tell us if this would be exempt under your rules? That's pretty standard. I do it across the state. Didn't get a response. We took title of the property in December of 2018. Still no answers. No, answer whether it was exempt or not. At this point, THF owned the property. THF, Texas Housing Foundation, and the Regional Housing Authority. It's a governmental body, not unlike the district here. Under section 392.005 of the Texas Local Government Code, all of the property that's owned by Texas Housing Foundation is exempt It's public property used for public purposes. There's also Texas Tax Code 11, Section 1111 has the same exemption. It's property that's owned by public bodies that are also used for public purposes are exempt from taxes. Those are two things that are pretty straightforward basis for Texas Housing Foundation property being exempt. There's constitutional provisions, Article 8(2)(a) that indicates that it's exempt as a matter of law without even asking for determination. So for those bases, I didn't follow up with I still hadn't got an answer to my original question, is it exempt? One of the big issues, I think, is the district views a for-profit entity as a part owner in this deal. It's a leasehold owner, and they've never sent a notice to anybody but Texas Housing Foundation. Texas Housing Foundation is exempt as a matter of law. All their property is. So if they're trying to tax some other party for part ownership of this property, they need to, by law, give that person a notice. They have not sent a notice. Tax code section 25.19 requires this notice.
Okay, if I could interrupt for 1 second. I understand you're getting into some details about the ownership, taxes, stuff like that. At this juncture, I think the question on the table is any information you have that might support or not your request for granting a hearing for tax years 2019 and 2020.
We had made a predetermination request after we took title of the property. We made another determination request. There's no promulgated form for an exemption for this type of deal. There's not a form that says this is, it's a unique deal. It's affordable housing. So I after we took title of the property, I sent that deed in also with some other supporting documentation, and then again asked for a determination. Still received no response. So I mean, the issue is really, I've made more than one request to the chief appraiser for determination, have not received any answer to it.
When was your second request? What year was your second?
It had to have been 2019 because it was after we took title, which was December of 2018.
Had to be.
But those requests,
I mean, it's in your files. I don't have it right at my fingertips.
okay. Clarify again for me what the requests were that you made to the appraisal district.
Seeking determination of exemption. I mean, it's they're in lieu of.
And how does that relate to filing a protest? Did you file a protest?
I didn't even know I needed to file a protest. I hadn't received a response back. I mean, in order to protest something, you have to have some determination that you're protesting. I did not have an indication of what the appraisal district's position was on the deal.
I will say that I'll affirm that his recollection of some of the facts in relation to a reaching out or a dissemination of information is factual. I will tell you that I was not aware, of what he was really requesting at the time at the initial conversations. And I said, so are you some kind of charitable organization? So I was looking for a form. I'm looking for a form because I get requests for exemptions all the time. Homestead applications, ag applications, real property inventory rendition. This is something, and I'll agree with Mr. Ardina, that this is something, it's a one-off. It's something that's not common. And so I did reach out to my counsel, and the stack of paper was that big. I mean, it was huge. And then multiple papers, maybe even some follow-up to that. So I'll affirm that. But I will affirm that in the years in question, the property owner in question that we had, to the best of our knowledge, was Texas Housing Foundation, and they were given notice in the years in question. Now it's come to light, I believe, that that there is and this is getting down the road, but hopefully it will shed a little bit of light in reference to the notice. What's come out of this is that if you go down the corporate trail of the way that this thing is layered, It's the district's assertion that the Texas County Housing Foundation owns the land element. And there's Saltgrass Landing LP that owns the structures or the improvements on the land.
And we can get that to that.
But Texas Housing Foundation was given notice in the years in question.
And for the district, let me just say a couple of things. As it turns out, what we finally were able to determine was that the owner was asserting an exemption of public property, not as a charitable organization. While under one section of the tax code, a district is required to submit a predetermination letter, I believe it's 11.1825. There's no corresponding duty by an appraisal district to issue a predetermination letter if a party is asserting a public property exemption. So, and what a predetermination letter is under that other code section that deals with charities is essentially the charitable organization is asking the district to tell them if their organization as structured, if it goes into effect, would it be exempt or not exempt? What I usually do for clients when it's in a predetermination situation regarding charities, my recommendation is that the clients say that, that the documents in front of the client appear to satisfy the predetermination letter. However, if anything changes, there might not be an exemption. And if it turns out the property is not being used for charitable purposes, that would defeat the exemption as well. So there are a couple of caveats still in the letter. But in this instance, since this is a request for a public property exemption under 1111 of the tax code, we were under no duty to issue a predetermination letter. In the meantime, you heard Mike say that the district sent notices of appraised value in 2019 and 2020. And so what we got in 2021 were finally the protest for those two tax years. I've got a couple of code sections I'd like to distribute to the board and to Mr. Andino that address this. It's only two documents. The first one, and I've highlighted the relevant information, is section 41.44 of the tax code, and it just establishes the deadline for filing a protest. And then the second document says, except it's provided by two specific chapters of the code, the appraisal role will not be changed. And what I mean by providing the board with the second document, once the appraisal role is approved by the ARB, then the role cannot be changed unless a property owner, sues the district or files a 25-25. Y'all know that. But here, nothing happened until June of 2021. So our position is under this code section 2525A, the district simply cannot change the appraisal role. And our position is that because of this text, the ARB would not be in a position to hear 19 or 20, because I believe the ARB would like the jurisdiction to hear those. That's the district's position with regard to those two tax years.
And let me reach out to the ARB council. Judy, do you have anything else to offer? Because I think that coincides with the guidance and direction that we've chatted about this evening.
Can I?
I think so. I agree. I think that's what I believed before I heard the evidence or the arguments from both sides, and it's still what I believe, because the fact that you don't have to file an application, which I totally agree with, does not mean that you don't have to protest timely when your property is capped. So that's what happened here. They didn't file an application, so there was no termination of an application, but the property was on the roll, they got a notice of value, that requires them to file a having a protest. So I don't think, if they did for those 2 years, I don't think they're entitled to protest.
Okay. And Dominic, you wanted to say?
I just wanted to add that under this statute that was handed out under 2525 B2, one of the bases is the name of the owner of that property. And again, if they're alleging that a for-profit entity has an ownership interest that's taxable, that entity needs to be part of the notice process. Actually, and even Texas Tax Code 41.46 indicates that if there's a leasehold interest, that the AG's office needs to be notified.
Okay, I think at least what I've heard from the district's council as well as the ARB council is all that's quote interesting. It does not alleviate or modify the requirement for timely filing of protests. Am I misstating that?
Yes,
No, you're not misstating.
That's what I.
Okay,
And just one other thing, I would point out that according to the notice of the protest, Texas Housing Foundation is identified as the only one. There's nothing in these about fault branch.
And I will note there's a public recording where in the county deed records of a memorandum of lease, ground lease that deals with the partnership itself that indicates the leasehold interest.
I would like to welcome briefly, if you're protesting the ownership of the property, that may apply, but you're not, I mean, you're not protesting the ownership, you're protesting. Now, ownership is a factor in determining that, but really, I don't think that is applied here, because this issue here is not just ownership, it's qualification for an exemption.
any more discussion? Okay, I think we're of the opinion that the ability to file a late protest for 2019 and 2020 not be granted. And we all, so we'll make a motion on that.
Yes, I'll make a motion on, case item 2022-2023, account 27852. That in considering all aspects of the request for late protest for the 2019 and 2020, that the ARB is of the opinion that these late protests not be granted.
Second.
Okay, all in favor?
Aye.
Anybody opposed? Okay. So at this point, I think we still need to probably make a motion or determination on 2021, which according to at least what I've heard so far, the request was filed timely. And as such, I think it should be granted. There's a good cause and it should be granted.
Okay, on behalf of the district, I would suggest that the ARB hear argument and evidence on that point, because the district's position is that it was not filed. However, there is an opportunity for 21 for the owner to show good cause for late filing. We do not believe that there's good cause for filing.
You want us to know?
21.
Well, not yet.
Not yet.
In the same way that we supported discussion on both sides for the addressing 2019 and 2020, we should also allow discussion on 2021. Okay. So, Dominic, I think I'll allow you to Yeah, thank you. Thanks, Amy.
Yeah.
Does anybody else need water? It's pretty rich.
Please.
Yeah, we'll go on then.
Yes.
I don't have a predisposition about who goes first, so Dominic, you want to go first? I'm going to go in 2021 request for late filing.
My argument are not necessarily anything different. Frankly, what brought that to a head was I filed a lawsuit in court to declaratory judgment action in order to have the judge determine the rights of the parties and connected with this exemption. And counsel for the district filed a motion to put that on hold because we had not appealed to the district. So that was the point where I filed a motion for a late hearing to appeal to the district. And here we are. Again, I mean, not having received a determination one way or the other, I didn't know that there was anything to really protest.
Okay.
The text rules do, in fact, say, don't indicate there's an exemption, but under my experience handling things in every other county in the state, there would be some notification that protest was warranted.
I'm not timing this because against.
Yeah.
Yeah, I mean, that's,
You're finished.
yeah,
The district's position is that the notice of appraised value 2021 did constitute notice to the owner that the district did not believe that the property was exempt. So once notice was received for 21 by PHF, and the clock began to run to meet that deadline, contained in the top page of our email,
Right.
and our position is unless there's good cause, and I think the ARB has probably heard good cause hearings in the past. It's we all know what it is, and I would respectfully suggest that just the mere fact that there was a lawsuit filed does not constitute good cause. We have to show good cause for late filing.
Can somebody run through the dates upon which?
Yeah, in 2021, as far as the delivery of a notice, the notice deadline date was May 28th. The receipt in which you have the packet where that letter is dated, I believe, June 28th. So
June 28th to 21?
or 21. The protest deadline for filing a protest on the property in question was May 28th of 2021. It's just that it was delivered prior to the roll being accepted by accepted by the ARB. So it was before July 25th, but it was after the deadline date for the protest in question, or for the protest deadline.
And Mike, the notice of appraised value then was sent on or about April 29th, I believe.
I believe that's correct.
And
It was 30 days prior.
it was sent by regular mail
28 regular
to the THF.
the THF.
And that was in 2021.
That's correct.
When was the lawsuit filed?
Dominique, you want to weigh in on that? Oh, they have that.
that was filed May 19th of 2020.
May 19th. Very good.
2021.
Yes.
And what is the status of it?
It's
I'll get to be.
It's still pending in the district court hearing.
And I'm sorry.
I'm just gonna say, is the outcome of that affect the decision regarding the roof?
That's a good question. I guess the district's position would be, I mean, I'm trying to remember what we said in our answer. But I would imagine that we, stated that THF failed to exhaust administrative remedies, that is to say, to go to the ARB. I believe the district's position is that the type of action the THF filed, which is called a declaratory judgment action, is not an available remedy to THF if the remedies are actually in the property tax code. So, and I've got to think back, it's been over a year since I drafted that answer. So, but I suspect that that's what we did. We argued that there was a failure to exhaust administrative remedies in the declaratory judgment action, which is contained in the Texas Civil Practice Remedies Code. While it may be an appropriate remedy for some causes of action, where the tax code provides the remedy, it's not appropriate in appeals from tax code cases. So they should have exhausted, they didn't do it. And a declaratory judgment action is not available anyway, because they should have followed the tax code. So to answer your question, if the court agrees with the district's position and dismisses the lawsuit, then that would be the end of the story. I guess the court could decide that a declaratory judgment action is an adequate remedy for THF and order that the case goes forward, and then we try it on the merits. So there's not a definite yes or no answer. It kind of depends on where the court goes with our request that the court toss them.
If the court ruled in their favor, then they would have the opportunity to have a more protest, delay protest. Is that right?
I don't think so. I know our position would be that ship is sailed.
I have a question. I'm going to get these dates correct in my mind. April 21st, the letter was for an exemption.
The
April 28th was
And
the
well,
notice.
the letter states,
Yeah.
April 21st, request for protest appeal hearing regarding exemption for ad valorem taxes. And then June 24th is to file a protest for the taxes. Is that right?
I don't have the
Yeah, we're looking at two different letters.
This one right here.
oh yeah.
Right.
Oh, I'm sorry,
Did you say 21?
21.
No. There's only, the only letter that I believe
April
is.
21st, 2022.
Right.
Yeah, well, that makes a big difference, the 2022.
Yeah, I'm sorry.
Yeah, that I was confused.
I
Yeah,
don't need to.
The April 21st letter is basically THS position for this hearing today. But what the district asked ARB to take up is whether there was good cause for last year for 2021. So I don't think the April 21st, 22 letter factors in.
Okay.
So,
We're just going to 2021.
correct.
At that point.
And that was not filed till the property owner's protest was not filed till 22, right?
21.
June 4th of 2021, there's a certified letter that we received on June 28th. It's in your tablet at the bottom.
Okay,
Fourth, June 24th of 2021.
Yes, that's what I was looking for.
So our position is that the June 24th protest by THF was late. And without good cause.
Yeah, it was due on
Oh,
May
May 20,
28th.
right.
And therefore now it's a good cause case. That's our position.
So now it is.
Right.
No, it's the question before you, the question before you, is it a good cause?
Okay. Thanks.
Yeah, I
No,
haven't heard anything that would say it is.
right.
And the lawsuit was filed when, Mr. Odino?
May of 2021.
So you have that information as well.
Not considering the law.
Well, I
we
mean,
read
it's just information.
Right.
Yeah, and our position is that the lawsuit doesn't have anything.
And then we-
That was before the ARB.
I think it's basically the same in 2019 and 2020. I don't know why it doesn't seem to be any different in those two. You know, not exempt. Based on the same principle, I'm getting right here. I can't remember.
You okay, Joanne?
Oh, yeah, right. Thing
For
that
tablets. Act.
Yeah.
you went to where it never wants to go.
Yeah.
All right, well, I'm gonna make a motion on case ID 2022 to 2023, account 27852. And considering the property owner's attorney request for late hearing 2021, based on the information referred to the attorney for the property owner and the district's attorney and own attorney. It is the opinion of the ARB that we decline the request for late hearing.
I'll check. All in favor? Any opposed? Okay, the last item I'd like to get a clarification on is, and I am looking at a file, at least on our tablets, called 42522 letters and protest forms.
Yeah.
And it starts with a letter dated April 21st, 2022.
It's just the same thing, except it's not broken out.
Understand,
Okay.
let me reach my question here.
Oh, sorry.
The first property owner notice of protest says for tax year 2022. Now, when did the property notices go out, the appraisal notices go out for 2022?
I can give you that information.
I'm looking at it right now.
Jackie,
I got it. Hold on.
you could just say it out loud.
April 25th, 2022.
Okay, so
April
is it
25th.
possible to protest something before the appraisal notice went out? Because the date on the protest form is April 21st, 2022.
And Jim, correct me, but, you know, you have a property owner or property owner's agent that's identified a property in the year in question. It's prior to the delinquency date or the protest deadline, and therefore it would, as far as I'm concerned, would be valid.
Okay.
For 2022.
Yes. Okay, I'm just want
That's good.
Even
to
though,
cross all my.
even though the, notice hadn't been created yet, it doesn't alleviate, I mean, some people get ahead of the game and they just say, hey, I want to protest it now.
Yeah.
And that's without supposition, just trying to fill in the dots, probably related to the things that we've been discussing already, but more of the same.
Right. So at least in that other file that we were looking at, it was one protest that was filed that said tax years 2019-21, as opposed to three separate protest letters or protest forms. This one, this set of files has separate protest forms, and it just, you know, because I think we're getting, not necessarily incorrectly, getting into some specifics about the dates here.
I think this is a standalone 2022 protest. What you got reported now.
Yeah, But we're going down to the others, they were all dated the same date, 4/21/22. Okay, so on the one hand, if it could say, if they had been post dated, I might have questioned some of that. Okay, submit a 2021 protest with a 2021 date on it, even though we know that it was not created. Anyway,
So you, yeah.
I don't have any.
We're hearing.
Yes.
We're about to.
We're about to.
So what next is the protest?
Okay.
22?
I agree. I agree that it's timely filed and it was valid.
That's what we're hearing here.
Yeah,
All right.
okay, now,
Do we have something? Oh, yeah.
I know the desire right now is to move on to deal with the 2022 protest. And my only question goes back to our council to say, Judy, are you comfortable with being around, or have you had a chance or enough time to be able to contribute to that protest?
I have no problem with it, and I would like to. If I yeah, my opinion on it. Quite a bit of the information, but not all of it, regarding the actual information. I don't know that I'll have an opinion today, but at the same time, you don't need to necessarily postpone it, a decision to get my opinion. If you feel comfortable with, you're going to hear the evidence from the property owner, you're going to hear the evidence from the district. And if you feel comfortable making a decision at that point, without me providing an opinion on qualifications, that's fine with me too. Either way, whatever y'all feel comfortable with, we can do. If you feel comfortable making that decision, go ahead and it's in order. If you would like to get my opinion, you can postpone the decision to do that.
Yeah. Okay, so, and that was the root of my question was whether we needed to, whether we would proceed today or whether we would postpone some action or even proceeding with the hearing until you might have had to have more opportunity to review the information. But let's go ahead and proceed. And then if we'll cover that, cross that bridge if we come to it. Is that fair?
You know what, and just a clarification, this is not a normal hearing where we're gonna strictly withhold the deadline timeline.
Yeah,
Because
right.
it is complicated.
Right.
I think all parties would agree. And then secondarily, there's two facets to this. There's the question of, like Mr. Adino's brought to your attention, the question of ownership as it relates to lease, question of market value, and then question of public interest. So there's several facets. So we'll go ahead and start.
Is that going to be laid out for us in terms of the 1, 2, or 3 elements that we are going to?
It will be
have
by
to-
us. I don't know about.
Yes, I anticipate that we'll go over the exemption aspect of it first. And then, depending on the board's ruling, I mean, if the board rules that it's exempt, then that's it. There's no reason to go into evaluation.
Right.
If the board rules otherwise, then that's a different deal.
Yes, okay, I understand. You guys, okay? Okay, could we take maybe a 5-minute break? And we just need to do the restroom and get, it's right there. It's weird. Yeah.
Sure, yeah, thank you. That's helpful.
That was fumbled with the electronics. I just made binders. I didn't make.
That's fine.
I just made binders so I wouldn't have to fumble through the bunch of things that we have.
Perfect, that works for me.
All right.
How many do you have?
I have 5. and
Okay.
I thought there was gonna be 3 member panel.
Okay.
Don't worry.
We'll share.
All right. Look on with your neighbor, as
Right.
the high school teacher used to say.
It's. Oh, my goodness. Billy, I'm back in school.
Yeah. Person that put my binders together. Big trouble here.
Yeah.
Let's put it here. It's okay?
Mhm.
Just you.
Really strength on the side of it, so there's.
Yeah, we need a bigger bond. And either it was gonna be that one or it's gonna be too big of a line here.
So
We'll get this one. You and stuff. Guess we'll share. I'm sure about
Wire and.
We have choices.
Your band. So. We ought to have a little painting. We won't try.
Do they get there?
When you say it was. Yeah, it was a talking sheet. Stand up.
You got one?
That's for the cookies too.
Oh, I got.
Okay. So have you been down to this building before?
no.
You miss the excitement. Because last year. In July, they had. The building flooded.
Oh, really? Great.
So we were working out as a portable building in the back until. Really, never a year.
Wow, yeah.
And so there's still some rough edges they're dealing with.
No glass.
I imagine I was envisioning some supply chain issues. That we have had with construction quite a bit right now. Windows are a popular item. Windows and doors.
We went for a number of weeks without anything, no doors, no
Oh, it's
nothing.
fine. You feel the difference when you walk in.
Sure can.
Oh, yes.
Can I have one?
Yeah.
Yeah, I'm sorry. I still have that record.
You're a fan of mine?
Let me go check.
You're
welcome.
Yeah, if they need to, we'll do that. It's on the tab, all this is on the tab.
Oh, is it?
Yeah, I don't know if it's tabbed in such a way where you can refer to it.
It's pretty much, you can, I can. A big meter. It's on,
No,
it is on 2022 hearings,
yeah, but. which one?
27,852.
You open today's deal.
Go
We did it
to
1:30.
1:30. And then 2022 hearings, 27,852.
It's right over there.
They,
Should we read?
no,
This
there's only two on the 22 hearings and protest form on prior years. It's the 2022 hearing, and then it all has down there. The taxpayer evidence, the last one is 173 pages.
There's no, it's Joanne, no cookies.
Oh, thank you, they have butter.
Right, yeah. It's butter on oil.
Is that the secret?
No, it's a combination of butter and oil and regular sugar and powdered sugar.
Oh,
No.
And it just gives you a totally different texture.
and is it almond flavor in it or?
I put vanilla in on.
Oh,
Yeah.
I love almond flavor.
You're gonna need to. swear in.
Yes.
Is Jackie still on the phone?
Judy.
I'm sorry.
I was like, I'm right here.
I believe so.
Okay.
She may be on mute.
Yes, I was.
Okay, there you are.
No question. They were just wondering whether you're still available. We didn't hear the
I'm
public.
here.
Okay.
And I'll try to-
Okay, thanks, Judy.
It's gonna have a case number.
Yes, same one.
Yes, 278.
Yes.
Number, yeah, 2023 is the case. number.
Bella only had 26%.
Okay, let me get a little.
Got a feeling we need more. Thanks.
Sure. Anybody else need one?
I remember I lost my house. Yeah.
You're 29?
Yeah, and I'm at 36.
But we rebuilt it. It's the nice. We always do it in all of this bad situations.
You think you look at the baby?
You put 30 to 20 something.
You took the paper that was up here? I took the what? The paper that was up here? Yeah, you had that
Okay,
very
perfect.
last.
I was like, oh, okay, just making sure.
Okay, you go ahead. Normally I would have the benefit of a script to go through. I think that's kind of, not required here. So all I'm gonna do is, commence a hearing on case ID 2022-2023, count number 27852. I will state for the record that this hearing is being recorded and streamed live on YouTube. And then we'll just skip down to swearing in the ARB members. The ARB members who are considering this protest have not communicated with anyone about the protest and signing affidavits to that effect. I, Scott Ryder, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
I have Hoffman, do solemnly swear that I will communicate with the person by tax.
I, Joanne Ferguson, do solemnly swear that I have not communicated with another person in violation of tax code section 41.66F.
I don't know,
Do I have-
swear that I have not communicated with another person about it.
I, Peggy Bird, do solemnly swear that I'm not communicating with one person in violation of tax code section 41.66.
And I assume it's still appropriate to have you swear in as well. Dominic?
I do solemnly swear or affirm that the testimony I shall present to the appraisal review board for the Aransas County Appraisal District is true and correct.
And if you will state your name.
Dominic Aldino.
My name is Michael Sutter. I can solemnly swear affirm the testimony shall present to the appraisal review board for the Aransas County Appraisal District is true and correct.
My name is Nathan Burke. I do solemnly swear and affirm the testimony shall present to the appraisal review board for the Aransas County Appraisal District is true and correct.
Okay, at this time, we would normally go through hearing procedures and times and stuff like that. I think the thing that's appropriate at this point is who goes first, and since you're the guest and the property owner, so to speak, I think you have the option of choosing who goes first.
I'll go first. Why not?
Oh, of course not. Yeah, thanks.
I thought you were a trooper for reading that long letter.
Anytime you're ready.
Thank you. As indicated, my name is Dominic Aldino. I'm a board certified real estate attorney in commercial and residential real estate. I'm a licensed real estate broker. I'm former certified real estate appraiser and licensed in Texas and another jurisdiction. And I'm also an intern for the HUD Office of General Counsel. Affordable housing is really what I do. I represent the housing, the property owner, Texas Housing Foundation. They're a Texas Regional Housing Authority. I've represented them since they were created as a regional housing authority in 2006. I'm very acquainted with their operations, their history, and the tax exemptions they secured in other jurisdictions. What I'm here for today, and my focus is really not necessarily what the property is worth, but whether the property is taxable. And that's the question that I'm posing. And this is something I don't usually argue in other jurisdictions. In this particular case, everything's in Texas Housing Foundation's name. This under Texas Tax Code 24.004, the land and improvements, if owned by different entities, are supposed to be listed in your rolls separately. They are not. Everything is under Texas Housing Foundation. Texas Housing Foundation. Well, if you under tab 1, I included chapter 1111 of the Texas Tax Code, which states except as provided by sections B and C, which don't necessarily apply here. Property owned by this state or a political subdivision of this state is exempt from taxation if the property is used for public purposes. Texas Local Government Code, section 392.005, that's the statute 392, under which THF was created. It specifically states, it's a tab 4, I don't know if you're following along or not, and on page 6, it says the property of an authority, meaning a housing authority, is public property used for essential public and governmental purposes. The authority and the authority's property are exempt from all taxes and special assessments in the municipality, the county, another political subdivision, or the state. And so under that basis, we are very comfortable in stating that Texas Housing Foundation's property, meaning the salt grass land property here, is exempt from property taxes. If you look further, well, so the main argument is really just only Texas Housing Foundation is listed at the owner of the property rolls. Their property by statute is exempt from property taxes. There are constitutional provisions as well that indicate that it is exempt from property taxes. Texas Constitution Article 11, Section 9 indicates that the exemption is self-operative, absolutely exempts the taxation from taxation of public property therein used, and it also indicates it is self-operative, and the exemption does not require a determination. So it's essentially once the deed vested title to the property in Texas Housing Foundation, the property became exempt. I did attach copies of the deed for your records and in my evidence. The deed is listed as Exhibit 8B, if you'd like to look at that. Now, one of the big issues is the fact that Texas Housing Foundation, the 8B is where they're. What is it?
8B.
8B, and I have a binder put together that hopefully has everything where it should be. So that's just the deed vesting title to the property in Texas Housing Foundation. That's recorded in the public records here. THF received the blessing of the city of Rockport in rebuilding the Saltgrass apartments after they were destroyed by Hurricane Harvey. There was an intergovernmental agreement that had to be in place in order for us to just exercise our powers as housing authority in the city. The city granted that. Tab 4 has a copy, tab 8A has a copy of the cooperation agreement. There's some other references here. The agreement that is in place with the General Land Office, they have another agreement that's similar to the City of Rockport's cooperation agreement. It's at 8C. That might be important to look at for a moment. Here you go.
And can I ask a quick question? Sure. In 8A,
Yes, sir.
the agreement between Rockport and THF,
Yes.
could you maybe reiterate what that agreement entailed and what motivated the agreement?
So because many cities across the state have their own housing authorities, there might be the city of Bastrop Housing Authority or whatever. Here, because Texas is a regional, Texas Housing Foundation is a regional housing authority, they have jurisdiction statewide, but it's subject to entering into one of these interlocal agreements that is 8A, just in order to exercise their powers within the city. So they have to have the city's approval before they can come in. And so there were public hearings and city council meetings, what have you, in order to authorize Texas Housing Foundation. That's another governmental body coming into this governmental body jurisdiction in order to build the apartments. The cooperation agreement and the resolution approving it are A.
And again, I'm sorry to keep it on. The thing that's confusing me is the timing. Because this agreement is from 2017.
Mhm.
And it was my understanding, you guys didn't get the property until 18 or
Correct.
19?
Yes, yes. Yeah, so after, we were in the process of buying, the apartments to refurbish them, and then Hurricane Harvey came and just destroyed them. And so, yeah, we've gotten the cooperation agreement for the same purpose. It just wasn't, the scope of the rebuilding became a little bit larger after the hurricane came in and wiped it out. All right, so the original idea was to just, renovate them, but the hurricane came in and changed things. Okay, so did that answer?
Yeah, it does. Yeah, thank you.
And New York is on these because,
The entity that owned the property before we did was from New York. Texas Housing Foundation acquired the property from them.
and that was Seagrass
Sawgrass.
or
So-
Sawgrass.
Salt Landing Apartments Limited. Yes, that was,
That was who you bought it from?
yes.
So why is their name still around? I mean, I keep on hearing it today.
The apartments are named Saltgrass Landing. And so a lot of times what happens in these deals is the lender requires whoever is obtaining financing to create one entity that only has one asset. So that way, if something goes wrong, they don't have to fight with other creditors and other people. So this is a single asset entity. The old name was DHF Saltgrass Landing Limited, or Saltgrass Landing Limited. The new one is DHF Saltgrass Landing LP. So Texas Housing Foundation had to create an entity, a single asset entity for purposes of the lender, so they could receive funding.
Okay, so this is your agreement with us, with this county?
It's with the city of Rockport.
Why?
And that was done in 2017?
Yes, sir.
You know, purchased the property in 2018. Did y'all have other properties down there?
No, that we were in contract, and these things usually the pipeline before,
Okay.
usually takes a couple of years to
Sure.
get where you're going.
I just checked. Be clear on that.
Yeah, so without a cooperation agreement, we
Gotcha.
couldn't be
No,
there. So that's always the first order of business. If they're talk to the local entity that has jurisdiction and then get their approval of the cooperation agreement. Once you have that, then you can, consummate and purchases and those kind of things. So the thumbnail on these is affordable housing. Typically, some governmental entity provides some sort of financing that helps keep the properties affordable. In this particular instance, after the hurricane, the government, general land office provided financing. So that was the governmental entity's source of funding. In exchange for doing that, we have to cap our rents at it's tied into the area median income. So unlike other properties, we only have a maximum rent that we can charge. And in exchange for that, it's understood that we get tax exemption. And, the city, I'm not saying the city said that and brought us in here under those circumstances. That's typically the way these structures work. In this particular instance, the general land office, we signed an agreement that's in 8C. And this is a restricted covenant that's on file in the county records. If you turn to the second, pages aren't numbered. 5. Turn to the 5th page, it says rent limitations, section 4.1. It indicates the various limitations that we are restricted to the purposes of renting apartments to others. So that is, in a nutshell, where our exemption roots from. The Texas local government code at 392.005 allows housing authorities to have an exempt property, much like a library or fire station or what have you. With the idea being that we would provide affordable housing for people that most need it. That's really in that Texas tax code 1111 and this constitutional provision that's where our exemption comes from. I think where it's complicated things in this particular case, it's almost the same structure all across the state. Is there has to be a limited partnership, and I did put exhibit 3 kind of organizational chart that helps things. Exhibit 3, it's backward, but you're at exhibit 8. Yeah, if you look at it.
Oh, here, okay.
Yes. Exhibit 3, I just put together an organizational chart that indicates the way this thing is structured. The Texas Housing Foundation owns the dirt and enters into a ground lease with a limited partnership, and that's just the way these deals are structured across the state. There's usually a tax credit component, but in this particular case, it's the general land office funds that's involved. But it's the same concept everywhere across the state in the way we do these. We enter into a ground lease, a long-term ground lease with a partnership. The general partner is an affiliate of Texas Housing Foundation. And so we thereby control the organization, the limited partnership. The ground lease is just a way, frankly, we wouldn't make it this complicated at all, other than that's just a tried and true method of structure to secure a tax exemption. And that's the way we do it in every other jurisdiction across the state. We have these tax exemptions from up in the Panhandle down the coast. And I'm kind of rambling. Are there questions before I get any deeper in this?
You have a limited partner that is for profit.
Yes, almost every, yes.
So how does that affect the taxation?
It doesn't. I mean, there's a number of analyses that take place, and it's usually I'm not making this argument in this. But there's equitable title. It's a concept. That's why we put the ground lease in place. So that way the nonprofit has equitable title over the partnership. In this case, the partnership is not even listed as the owner of property. So frankly, the only one that should be taxed are the people that are the illicit owner, and they're exempt from any taxes based on the statutes that supply to you. But yes, there is a concept called equitable title that allows a nonprofit to have what's called equitable ownership of the property, and there's a ton of case law that says that that's acceptable in order to secure a tax exemption through these circumstances. And there's there's a number of larger issues, but the bottom line is that the only listed owner of the property is very clearly tax exempt. The property is tax exempt based on the local government code, 1111 of the tax code, and the exemptions, the constitutional exemptions that exist. And frankly, I mean, as a regional housing authority, we wouldn't develop apartments and agree to file documents in the county records that say we're only maxed out at, we can only charge this much rent when we still have the same operating costs, the same debt service, the same insurance costs, the same staffing costs, all the other costs that any competitor would have. So I mean, the give and the take is the fact that we provide affordable housing that generates, that provides places for teachers and police officers and frankly, people who work in retail industry and others to come. I mean, at this point, we have economic development corporations in various cities coming to us, and we put affordable housing in, so these big box retailers, other businesses will come to our cities. So that's really the analysis we go by when we go to town. Ordinarily, we have to kind of work through that with cities or counties or whomever the folks are that are in charge of the places where we operate. And now they're starting to come to us saying we have to have somewhere for these people to live. That is,
Did you pay taxes in 2019, 2020?
their taxes are still outgoing. I mean, they're still
You never paid taxes.
no. And that's the reason for the
Were you billed taxes?
the tax bill did come, yes. Yeah. I mean we did in the some state communication since we 6 months before. I don't.
Like you said, I had tax.
Right, we're not required to by law, so in order to do that, we have to create a precedent that affects affordable housing across the state.
Is it a typical, I'm sorry,
No, I
So is it a typical situation between having somebody own the dirt and having somebody own the improvements?
So
Which
much,
which it looks like is the case. Is that true? Am I reading that right?
more or less, yeah, yeah, it's typical enough to where the code, the tax code requires 44.04 that may be listed as separate ownership in the tax rolls. And they're not listed as separate ownership, and that's despite the fact that we have placed the district on notice. I mean, how districts find out that property has changed ownership is they look in deed records. In the deed records, we have a memorandum of ground lease that places everybody on notice that there is a ground lease in place that separates out these ownership interests, at least this leasehold interest. And, yeah, so in order for the district to be able to tax us for the leasehold interest, they must list the leasehold holder, and in this case, stay unknown.
Basically, what you're asking us to do is change your status on our record so that you are not taxed.
Yes, I mean, by statute, we're exempt. I'm just asking the district to acknowledge that. And that's typically we don't file lawsuits. The lawsuit that's on file currently is asking for a judge to determine it for us because the district will not.
Is that something we have the authority to do?
To change ownership.
No, to change status.
Well, I believe it has to do with the granting or not granting of an exemption.
Well, for the record, there's several things on the protest form. One has to do with the incorrect property ownership limit. The other one has to do with incorrect appraised market value and equity. And the other one is exemption of non-modified opinion. Those are the things in the protest for 2022. We haven't even got to our part on what we would.
I can address all of it.
Okay, it's coming up now, and if I don't get it out there, I'll forget it by the time I get
I will read it.
Thanks, Judge.
Yes, you're welcome.
And we didn't mean to interrupt you.
No, it's fine. It's fine.
Sorry.
If you have more to present.
I mean, I certainly welcome any questions. But I feel like, all right, yeah, I'll just pass the torch.
Let me get a copy as well.
That enough? Yeah. Here.
If you need more over there.
Everybody have a copy? I think you got one.
Yes.
So what, I'm going to say as a threshold is that the district is fine with exempting the land. The land component is owned in fee simple by Texas Housing Foundation. We don't challenge THF's assertion that it's a government entity that is authorized to do business in the city of Rockport. That is fine with us. We can treat the land as so that brings us to the improvement part of it. And the district's position is we'd like the ARB to do what DHF is asking and change title of the improvements in Saltgrass LP. You notice that in Exhibit C, 8C of their packet, which is the owner's packet, they identify themselves. Saltgrass identifies itself as the owner of the improvements. They're referred to as the developer style improvements. So we're fine with that as well. Putting Saltgrass, I believe it's called THF Saltgrass, as the owner of the improvements. Now, the next question is, so what about the improvements? Are they exempt or are they taxable? And the first tab in our handout is from Texas Tax Code section 1111A. This is an excerpt. This isn't the entire 1111. Highlighted one word in that word is on. Subsection A says, except as provided by subsections B and C, which are not relevant to this conversation. Property owned by this state or political subdivisions is different from taxation. And as council stated, ownership has been construed by the Supreme Court to mean political subdivisions, other states or political subdivisions means other governments, not just the state or the county. But in order for property to be exempt as public property, it first has to be owned by the government. So the question is THF the owner of Saltgrass? Does THF have equitable title, thereby making the Saltgrass landing improvements exempt? The district position is that the answer is no. That THF does not have control over Saltgrass Landing LP, and therefore does not have equitable title, which would mean under the case law that the title should be in THF as an exempt entity for the improvements. The second tab kind of explains that. This is an Attorney General opinion. It's GA 0485. Before Governor Abbott became governor, he was Attorney General of Texas. And one of the things he addressed in AG in 2006 was a question from a state representative, Talton, who asked General, at the time, General Abbott, whether property used for public purposes and otherwise and owned by a limited partnership composed of a political subdivision, 100% dual apartment, private or profit, nonprofit entities in the role of partners is exempt from federal taxes. That would have highlighted in the first paragraph. I think that what was asked by Representative Paulton is what's before the ARB today. Are the improvements exempt or not? Because the improvements are owned by a limited partnership, Saltgrass. General Abbott basically says in the opinion, this is a factual matter. There's no real clear cut. But what's valuable about the opinion is General Abbott presents kind of a treatise on the cases that tell you when property is exempt and when property is not exempt, when it is owned by somebody other than a qualifying entity. So remember here, we're fine with THF as a qualifying entity. We don't challenge that it was a regional housing authority. We don't challenge that it's authorized by Rockport to do what it's doing by constructing the new Saltgrass apartments. But the question then is THF's relationship to Saltgrass enough to give it equitable title to make the property exempt from taxation? So some of the cases that the Attorney General discusses is kind of back and forth. But one that I want to focus on is actually a case in which the one of the courts of appeals held that the subsidiary organization, which is the fee simple owner, is is not the owner for purposes of taxation. And that is on page 4, some more highlighted text where the Attorney General says another court of appeals found equitable title in a similar claim. Harris County Appraisal District versus Southeast Texas Housing Authority. That was the criminal case. Southeast Texas Housing Authority was a subsidiary of, I'm sorry, they were the qualifying organization. They owned a subsidiary that didn't qualify, didn't meet the requirements to be a government entity owning the property. But the subsidiary could be put out of business by the qualifying parent company. They had what we call interlocking boards of directors. They have the same boards of directors. Southeast Texas Housing Authority could compel delivery of legal title to itself. In other words, Southeast Texas Housing Authority, the qualifying organization, could tell its subsidiary, give it back. We want it back. The subsidiary would have no choice but to give it back. In that case, the Court of Appeal said that the qualifying entity, Southwest Housing Authority, had equitable title, which made the property exempt. The cases that are discussed earlier in the Attorney General opinion talk about things like contingent beneficiaries, contingent interests, where the qualifying organization has no control over when or how it can acquire control over the subsidiary or the fee simple. One of the cases has to do with the toll road authority that's mentioned in here. Supreme Court held that the toll road authority was not the owner. The toll road contractor was, because the toll road authority, the Texas agency, could not compel delivery of legal title. Certain things had to happen that were in the control of the fee simple owner of the highways in order for that to mean that the state had equitable title to the improvements, thereby making the improvements. So what General Abbott says in GA 0485 is, among other things, if the qualifying organization that is not the fee simple nevertheless has the ability to compel delivery of legal title to itself. In other words, has the ability to tell the subsidiary, give us the property, we want it back. Then, in that instance, the property would probably be exempt because the qualifying non-owning entity does have the ability to take it back. That would give it what's called equitable title. So our position is, if you look at the way the limited partnership agreements are structured, and those are tabs 3 and 4. There are two partnership agreements. I'm not sure why there are two, but there are two. But they identify the parties, the players. The general partner in the partnership agreement, the Saltgrass Landing LP, is THF Saltgrass Landing GP LLC, which is a company wholly owned, wholly controlled by THF. So effectively, THF is the general partner of this entity. There are limited partners. Actually, at the time, there was one limited partner, BHHH Companies. But nowhere in either agreement, in either limited partnership agreement, is there any mention of any ability by THF Housing Development or Saltgrass Landing GP LLC to compel delivery of legal title. It's just not in either agreement. Our position is that THF does not control the ownership limited partner, the ownership of owner of the improvements, because it cannot compel delivery of legal title. It does not have interlocking boards of directors. I suspect that if THF went to the limited partners and said, we're taking the property back the limited partners who are investors would probably go to the order. They would probably say, you're not gonna take this away. So that's simply our position. It's pretty straightforward. That, you know, THF would be the qualifying entity. And we don't take THF to task for what it does. With, you know, THF is satisfying a need in the community. But for whatever reason, the limited partnership is the owner of the property. And like I said, our position is, since there's no ability for THF to compel delivery of title back to itself, it's not the owner, whether legally or equitably, and that the improvements, the solid waste improvements are taxable.
You're saying that THF owns the land. And they are exempted taxes for the land.
We'll agree that yeah, we don't have it exempted at this point.
No, I'm
But
saying-
we'll agree with THF that the land component should be.
Sawgrass. That is, the partnership involves the apartments. Improvements.
Yes.
Improvements would be taxable.
That's our
Because of
position. Yes,
Right.
the improvements are taxable.
In as much as it relates to the property protests, one of the things indicated is the owner is incorrect. The remedy for that is to take the one parcel and to split it into a land only account into an improvement only account.
Okay, yeah.
And then you would make one, again, like Jim has indicated, one that the public entity, and the other that is not a public entity. And therefore the improvement or the structure is taxable. And the land element would be afforded all the rights and privileges associated with the Texas Housing Foundation promulgated agreement for regional taxing.
Or, and I'm looking at the chart here, your chart. The bottom left two, PHF Housing Development Corporation is one entity that they own the land, and the guys above, is that what you're saying? The GPLLC, PHF Saltgrass Landing, does not have sufficient
Control.
well, they can't compel, the LP to basically take back the property. Now, the structure, correct, because the structure is in the general partnership, is that correct?
The structures are in the limited partnership, the LP.
Yeah.
The GP will agree is controlled by Texas Housing Foundation. They are the general partner. Actually, I believe they're the sole member of Saltgrass Landing LLC. Is that right, Nick?
The Housing Development Corporation is, yes.
Got it.
That was.
Okay. But the problem is that the project owner, is Saltgrass Landing LP. And our position is that it is not subject to the control of either THF or THF Saltgrass Landing GP LLC or THF Housing Development Corporation, because of the way the agreements in tabs 3 and tab 4 are structured. You've got a general partner, which is these guys, but you've got all these limited partners who own, I think, more than 99% of the overall partnership interest. And so, like I said earlier, there's no control, there's no ability to take the property back. Then it would there's no equitable ownership by the THF entities. And so the improvements, the apartment complex is thereby taxable.
Why is the line between 50-year grounds between the private.
That's a good question. As I understand the transaction, Saltgrass Landing LP also leases the land from THF. So they are the tenant in the land and the owner of the apartment project improvements.
Okay. So, yeah. At least one.
So who they own? Is there any oversight by the general partners then? Or what is it, THF? Thank you.
Yeah, I guess Mr. Rodino could probably address that part of it.
Is there oversight,
Yeah.
meaning what?
Meaning, how things are kept up, how, the rents are applied.
Yeah, yes, so, and I have I have a different version of that same org chart on tab 3 that indicates that the board of directors, they're interlocking. So Texas Housing Foundation's board and the THF Housing Development Corporation's board are the same exact board members. That's how THF controls the partnership. And as a general partner in any limited partnership, the general partner is kind of responsible for the day-to-day operations.
Didn't you indicate that was one of the issues
That there wasn't more.
boards weren't interlocking with the street? That was a problem.
Yes, our position is that the LP, who's the owner of the property, does not have interlocking, as one position, does not have interlocking directors with THF or any of these THF entities on the left-hand side of the chart. Because of, 99% or more of the LP is comprised of a limited partner or partners that is an entity other than THF.
And that's, our position is just the opposite. And frankly, the Attorney General's opinion that was provided by the district is also provided by us, and we frequently cite it in support of our position. So the issue, there's a couple different issues. One is there are interlocking boards, and just in general corporate law, if there's a limited partnership, the general partner is the one that's in control of it. THF has control of the general partner through THF Housing Development Corporation and through the interlocking board of directors. That's.
But if you own 90%, don't you get more members on the board?
The limited partner has no members. Yeah, it's all through.
Even if they own 90%?
The limited partner has no members on the board, but you just stated that they had interlocking board.
No, I say the THF, Texas Housing Foundation, and THF Housing Development Corporation have interlocking boards. They're
Yeah,
the general partner, I don't know, maybe that's the people are putting lost in the weeds. The general partner, which is the one that controls the partnership, is controlled by THF.
but through the LP,
boards.
but the LP. Right, go ahead.
Exactly. The limited
That's-
partnership, our position is that the limited partnership does not have the interlocking.
That's exactly.
And
But
that's,
the limited partnership happens to be the feasible owner of the apartments.
and that's not what the law is requiring. It's for the limited partnership to have interlocking boards.
That's one of the things that's addressed by one of the court opinions. Really, the main thing is the ability to compel the legal title. And we're not seeing it in the organization body.
Well, if I can address that, in exhibit 7. That's the amendment ground lease. And sorry, you don't have what?
No,
Oh,
we're okay.
Yeah, on tab 7, pages 7 and 8. This is where that language comes into play.
Holding over.
3.4 at the bottom. It indicates, yeah, for federal income tax purposes, tenant alone shall be entitled to all of the tax attributes of ownership of the improvements. At the expiration or earlier termination of the term of this lease, or any portion thereof, tenant shall peacefully leave, quit, and surrender the premises subject to the rights of residents in possession of units. Meaning they can't take the tenants out, but the partnership will surrender its rights. Upon expiration or termination of the lease, the premises, improvements, and equipment, or any portion thereof terminated shall become the sole property of landlord, which is Texas Housing Foundation, to be operated in accordance with chapter 392 of the Texas Local Government Code as amended at no cost to landlord, and shall be free of all liens and encumbrances other than permitted. Blah, blah, blah. And it says, notwithstanding the above, for state real property tax purposes, or to the extent otherwise required under applicable legal requirements, to maintain the real estate exemption for the property, landlord shall be treated as the owner of the property. Is the parties' intent that landlord hold title to the property at all relevant times, and to the extent it does not, landlord can compel legal title to the property to be conveyed to landlord during the lease, if necessary, and by automatic operation of law pursuant to this lease at the termination of the lease. So that is saying that the landlord, which is the partner, THF can compel the partnership to do just what is required based on the Attorney General's opinion and by automatic operation at the termination of the lease.
So the compelling part is where I'm getting confused because this talks about early termination of the lease. And that seems to me might be a narrower situation than having a parent for whatever reason, not just the termination of the lease. And tell me if there are other reasons why a parent can compel. They could just decide to, right?
That's, as I understand the case law, yes. I mean, if the parent simply decides it's over, we're compelling delivery. But let me point this out too. This section 3.4 really is an admission by the parties that as long as the lease is in effect, the improvements are owned by Saltgrass. It's not until the lease is over, until they revert to the PHF.
Right.
There's case law on that too. I haven't got that in front of me, but
Who's able to terminate the lease?
well, I mean,
TH one to terminate.
I mean, as I understand it, it can be terminated, it can be defaulted like any lease, or it's terminated at the end of the lease.
But it does say that tenant shall be entitled to all of the tax attributes of ownership of the improvement,
And
which said,
we take the position that that's a federal tax issue. It has nothing to do with state law.
right,
It says for federal. income
it says
tax
for
purposes.
federal income tax. Yeah.
I would just point out at the last sentence where it says it is the party's intent and this, and the whole thing is structured so that there is a tax exemption so that we can provide reduced rents to people. And it indicates it is the party's intent that landlord owns title to the property at all relevant times, and to the extent it does not, landlord can compel legal title to the property, which that's the litmus test that the district council has described as being the thing that allows the whole structure to fall under exemption or not. It's the ability to compel legal title.
At termination. At termination.
termination.
Well, it is part of the landlord whole title. of property
Yeah,
at all relevant
there's a
times.
distinction here with respect. I mean, on the landlord, I just say it's over. And you meet your stuff tomorrow.
I
That's
don't-
not gonna happen.
I don't think we're reading the same thing. It is the party's intent, but landlord whole
Take
title
the
to the
end of
property.
your own documents, sir. It says at the termination of this lease. It's your document.
I know it's my document. I'll read it and it'll hopefully make sense if you let me finish it. It is the party's intent that landlord hold title to the property at all relevant times, and to the extent it does not, landlord can compel legal title to the property to be conveyed to landlord during the lease, if necessary, and by automatic operation of law pursuant to this lease at the termination of the lease. So that means there's no forcible detainer action, there's no eviction that has to take place after the fact. That's at the termination of the lease, it automatically operates to go back if it has not before.
And I think my question is, and I believe Mr. Soto's question is, what can cause a lease to be terminated?
Any number of things.
But it
it's
also,
assets-
I mean, it is required that there's a lease termination that drives this 3.4, as opposed to other considerations that could drive a parent to compel the child to convey.
Yeah, I mean, this is a product of case law that's taking place, the statutes that are in place, and a number of other things in order to meet the legal test for a tax exemption. And I think, it's probably gonna be a little. That's, it passes much better than every other provision we operate on. So this means the law is different. The ramp is coming. Hopefully it is.
Now, just to see where we're at, we covered the fact that the district doesn't have a problem with accepting
The land.
the land.
Right.
You have a problem with
Exempting those.
exempting buildings.
Based on the corporate structure.
Yes.
Yeah,
That's right.
Those are two things that are going to protest. The third one is the valuation of the structure.
We have
The remedy,
We haven't.
the remedy for the property owner's agent, checkbox where it says that the incorrect property owner, the remedy for that is to separate both the land and the structure into different accounts, make one taxable and one not. But again, that's why it's before you. No, it's before you. Because the subject property owner's agent has indicated that
It's the wrong name.
it should be a leasehold and the leasehold owner, or the leasehold, the owner of the improvements is Saltgrass Landing LP. Is that your assertion, Mr. Avina?
My assertion is if you are going to tax them as the owner, it has to be on the rolls as the owner. That's my assertion.
Yeah, and the remedy for that is to put them in two different accounts.
But is your position that you can retroactively go back and tax them if they went on the rolls previously?
Jim?
Well, I mean, the ARB addressed the previous years. And I think that.
Yeah, we,
So right now, we're talking about 2022. And, just kind of want to address 3.4. The way it's worded is the party's intent that the landlord hold title. I'm not sure that is, an absolute statement. I mean, the landlord hereby holds title.
It case law actually indicates that they do contractual analysis to determine the party's intent. It's part of the reason why it was drafted in that manner, just to address.
Well, it could have said that, that landlord hereby holds title to the property. Why would you have a lease to a tenant if the lease says that it's the intent that the landlord is in? I mean, it's the owner of all the property when they've got these other agreements in place. Like in the recitals in tab 8C, developer THF Saltgrass and P, owner, so they make admissions in the public record as filed in the court. That the LP is the owner of the agreement. So, our position is that this last sentence in 3.4 doesn't quite get it. If they want to be unequivocal about it, they could say, something like, the landlord hereby holds legal title to improvements, things like that. I'm not sure that the intent gets them there. Why weren't they unequivocal? Stating who owns the improvement, the intent. And the reason I think they've got this somewhat vague language about intent is because they understand that they have limited partners in the mix. And the limited partners are not going to want they're not going to agree to THF taking the property away. THF wants to. So our position is that notwithstanding this last sentence, it's still taxable to some press.
Is there any other remedy in terms of modification, not to say that it would be suggested or maybe even possible, but a remedy in terms of a modification to ownership that would support both the land and the improvements would end up having to be in the same entity, right? Or in a relationship with interlocking boards and stuff like that.
I didn't understand that.
Sorry. Okay, so what was suggested is, at least for the protest item, which says, the names are incorrect. Okay, that you separate, create two accounts, one which would hold the land, another which would be exempt, and another that would hold the improvements, which would not be exempt. Is there any organizational that could be created that would allow both the land and the improvements to be held in such a way that they would both be exempt?
Yeah, I think the PHF had a subsidiary corporation that had boards of directors that were the same, essentially an entity that could be controlled by PHF. And yeah, I think that would work. I mean, if PHF had a subsidiary that say follow the facts in Southeast Texas Housing Authority, where you had all of that interlocking board members, the guarantee of the promissory note. And one of the things in that case was that the parent corporation, I think, guaranteed a promissory note that the subsidiary executed things in positive stuff. But in the Southeast Texas case, it was way more controlled by the parent over the subsidiary than we see here. So I think the answer, if I'm understanding the question, the answer is yes, it could be accomplished. But the ownership entity has to be structured in such a way that there's control by the parent.
That's what's.
Yeah, we need to work.
No, well, yeah, right. At this juncture, I agree, yes.
Well, that's THF's contention that not only is the case in this, every factor in the Southeast case has been met in this structure. I mean, it's, I don't know how else I could diagram it, but the board chart in chapter 3 indicates that the boards are the same.
Which board is the same?
The boards of Texas Housing Foundation, its subsidiary, which is THF Housing Development Corporation. It's the sole managing member of the limited, the general partner. Most limited partnerships don't have.
Are they the same?
Effectively, THF controls the limited partnership through the board of the general partner, which in general corporate terms always controls the general partnership.
But you said they had their vote. That was my understanding from earlier. You said that the same members were on the same, on those boards.
They're not,
But not on the.
But-
yeah, not on a limited partnership.
Yeah.
And I
See the picture.
don't know if any limited partnership has. a
That's the same, you got this in the middle, and then the question is, if I recall, these are the guys that own the land, right? These guys.
Yeah.
Yeah, Texas Housing Company.
It's a matter of language.
Yeah, and then if you look at any of the cases we're referring to, there's not some separate board of directors for a limited partnership. There's a board of directors for the exact same.
Interesting question. It was just, I think it's irrelevant to the specific situation.
We haven't presented any information in regard to, I mean, I guess, I don't know if you want to rule or table, or is your counsel on speaker?
She's probably on mute, so Judy, if you're,
I have a comment or two, actually. I believe that what I've heard or and seen, because I have been through everything. And the one thing that I know is missing, I guess, is the partnership agreement. From that partnership. I mean, there's no partnership that I can see. All I can see is I grow the there's no that the partnership agreement is important because in detail they need one the general partner and the limited partners. And we don't know when it's going to. So I don't think that we can.
Yeah, and we actually, Judy, we actually neglected to give you the partnership agreements. The board of directors has them. They're in our packet. But you don't have a packet.
All right. Well, if I did, I would look at it, but I don't. I guess what I see so far is that I haven't heard any evidence showing that the general partner under the partnership agreement has the right to control the agreement during the term of the lease. And that's important. If you look at that attorney general GA or July, that is one of the criteria that the attorney general that they're first of all, the attorney general mentioned, and this is important too, that a general partner of a limited partnership only does not own any percentage of real property. And the general partner only owns a partnership interest in the partnership, the limited partnership. So I think it's a mistake to say just because the general partner is a public entity that they should be considered the equitable owner of property owned by the limited partnership. That's one thing. The other thing is, because it's the two cases which told public, and it did not.
Judy, can you maybe get a little closer to the phone?
Yeah, I'm sorry, I'm sure you have. But yeah, title is has to be a right to transfer the field. And it is such as so there's a lack of evidence of ownership from what I've heard, other than this intent.
It's helpful.
Very.
So can we address the two issues that are on the table right now? As a last thing going to the evaluation department.
So y'all ready to get the valuation part of it?
No, we do these two things, get them out of the way, and then
I don't know.
we're glad we did all things.
What two things? It's up to y'all.
We got the exemption of the land and the
Ownership.
Only the land improvements. Right.
which we've already, I think, pretty much have a sort of agreement on. We haven't discussed yet evaluation,
Yeah,
but should we wait until we don't agree?
Before we need to get out of the way.
I believe the way it's been presented by the property owner's agent is that, there's two distinct owners, for the land and the improvements. Again, we would, say, I would say, the district representative, that we would, the remedy for that would be to separate those two, for the 2022 year, in which we just now, and I say just now, Nick Rodino has been, has worked in good faith to try to get me the documents. They're beyond my level. There's a lot here. That's why I got my counsel involved. And you'll notice the last date of the last submission was April of this year. So, again, this is beyond what I'm used to looking at. Having said that, he brought things to the light that, do have remedies. And one of those is ownership. The remedy to that is separating those two. And then we would have to give, proper notice for that new account. Is that right? Or that handled?
I think the ARB can make the decision on ownership.
Yeah.
But to address your question, I think that, the district's position is that the ARB should decide on whether the improvements are exempt or not before deciding on valuation. If the district says that they're exempt, then you're not going to rule on valuation.
So if we rule on the land and the improvement,
We have it at one unit right now, and you can discuss the apportionment within, after, again, it's our suggestion, but I mean, it's your board, it's your meeting.
Yeah, again, this is the district's position. The district is fine with the ARB determining first that the land is exempt. There's no dispute there. Secondly, the district position is that the improvements should be taxable. Third is that the improvements should be listed in the name of Saltgrass and LP. You would ask the ARB to make that decision. And then fourth, to determine what the value of the Saltgrass and LP improvements.
In between those, that last one, there was a exemption within I modified or canceled. You will have to rule on that.
And I want to clarify, my position is not necessarily that the land is one owner, improvements are another owner. My position is if the district, I think kind of dovetails with what the district is saying. If you are asserting that there's taxable improvements, it wouldn't be through THF, it would be through partnership. So if that is the assertion, they at least have to be separated for purposes of taxation.
Right, and
That's what we just said.
Well, you say
the
it's my
order-
assertion that one is owned by one and one is owned by the other. I'm trying to clarify that that's not my assertion.
Are they not owned by two different entities?
Two different agencies, no.
Is one not in control of Saltgrass Landing LP, the structures?
I mean, it's my argument, and I've been making it since 2018 that partnership is under the control of THF.
It's the district's position that,
We don't do that.
Yeah, your picture doesn't seem to
Yeah, that-
support that
no.
unless there's more than one partnership. See a limited, no, I can only see one partnership. Is there more than, is there a different partnership that I'm not seeing on your org chart?
There's only one partnership. I don't understand what you're saying.
You said it's under control of THC, or THF.
That's
It doesn't look that way to me on your org chart.
There it is.
Yeah. The guy in the upper right, project owner,
that's the partnership.
Yeah.
Yeah.
how is that under control of THF?
When you see where it says holder of fee title in the upper left, that's Texas Housing Foundation. You see the board members. And if you drop all the way down to the bottom of that page on the left side, that's a THF instrumentality. And those are the same board members. So they control, THF controls the general partner of the partnership. In the limited partnership. In the limited partnership, the GP is the one that controls.
That still doesn't matter because your LP is feasible.
Is not.
No, it's LP,
Is.
is the feasible owner of the equipment.
That's correct, yeah.
Well,
I think that, so, I mean, if you look at exhibit HC, they're making a representation to a state agency.
Are you saying the limited partnership? You're saying the LP, and I'm thinking you're saying the limited partnership. You might want to clarify that, because that's,
LP. LP is a limited partnership, right?
yeah, okay, I'm hearing LP, thinking limited partnership, or limited partner. It's getting confusing now.
Limited partnership.
Yeah, we didn't.
But, I mean, if you look at HC in the petition, this is an agreement between the general land office and the LP. And they tell the general land office that the LP is the owner of the improvements. You know, this is a recorded document. You know, notwithstanding what the lease says about it, you have to take it if necessary, whatever that means. And I think that the parties structuring this transaction have intended at all times that the LP is the owner. And you know, even though there might be interlocking directors in this entity, this corporation, EHF, the LP is the owner of the improvements, and like I said a few times already.
Yeah.
Of course, that's, and that appears to be one thing, it does, that's the help, so the agreement. And, so, I think, but that does not affect whether the increments are exempt. It has no effect on that. Because, you know, if the, which I believe, I agree with this, that the increments are in fact owned by the private LP. They're not exempt under the law. Unless there's a title, which, again, I don't see it as and as far as and I did comment on that one mention, and I can't remember exactly where it was now, but the equitable title is owned by the AHF or the exempt owner, unless, and this is vague, because it says unless they retake the improvement pursuant to the terms herein. But then I didn't see any terms herein that would limit them. So I feel like that's a little bit, I don't know. I think there's a choose of that. There's no that it would allow.
So Judy, just to be clear, I guess for the board's benefit, the last sentence in 3.4, where it says it's the party's intent that the landlord hold title of the property at all relevant times, and to the extent that it does not, landlord can compel legal title of the property to be conveyed during the lease if necessary. That is not controlling.
Well, it just doesn't really mean anything because it refers to if you're
It's page 8 of the ground lease.
I don't know what you have.
I do.
Okay, great.
Good.
It's section 3.4. Starts on page 7, but the owner's position is that the last sentence in 3.4 provides a compelling of legal title.
Still trying to find
What exhibit is that? That's
Oh,
exhibit 7.
Exhibit 7.
lease?
No,
Or-
Ground lease.
it's the actual ground lease,
Okay,
first amended ground lease,
and what page?
page 8. It's above the section entitled section 4 rent. It's the last sentence in the paragraph just above that.
Okay.
It's the party's intent. The landlord hold title.
Yeah, it says, yeah, again, it says, it's the party's intent, you know, that, I guess what I'm saying it's the party's intent does not actually provide a mechanism for doing that. I mean, you know, but it's one thing to say that's your intent, but as the, well, as the Supreme Court has said in these exemptions, just say it doesn't make sense. That would allow. the landlord to not put it for equitable title to be based on a law. That it requires that you have a right and without contingency, it's an unconditional right. That you, the person who has that right is in self-control of whether they or how they exercise that right. All right. And I just won't see that anywhere or anything that occurs that describes their right to just take that. At any time, for any reason, with, you know, and if that right is not within their control. I haven't heard that. That makes sense. I don't-
Lease is terminated.
Yeah, on the, little two issue, I think we move forward.
Yeah.
On the land, yeah,
Not working involved.
so put the land in THF. Is that what y'all saying?
The land remains in TA.
We're fine with that. We're fine with the land being a percentage.
And exempt, yeah.
Can I go ahead and make a motion?
Well,
I agree. I don't know what we are making a motion against. Okay, there's a notice of protest.
Because it says the name, Scott.
Okay, so change in the owner's name is incorrect.
Change, owner's name is incorrect.
Owner's name of what?
Of the approved.
Of the improvements.
No.
No, it changed, okay,
By the way,
this is,
I understand.
and then you decide whether.
it
Yes,
says change in use of land appraised as ag use, open space, or timberland.
I understand
So
all
that-
that. I'm trying to look at where does it say what needs to be changed? Okay? And I'm looking at a protest form. And
Owners,
I can look at the chart. But if I look at the protest form, where is the name of the entity that needs to have its name changed? Am I being weird about this?
You have testimony from the property owner if they do. Or you have testimony that our assertion of what we believe it is,
Yes.
well, and you also got,
the improvements.
you've also got documentary proof in the form, again, of HC, where, they identify themselves as PHF Saltgrass Land LLC.
And Scott, the protest form is one thing, but I think that that's more.
I-
About the ownership.
I'm okay if somebody can lay out and tell me, what is the name of the thing that I'm telling them to change?
The ownership.
The
Yeah,
ownership-
okay, so we're going to change THF Saltgrass Landing LP, which is the owner of the improvements.
PhD Housing Development Corporation.
The land.
Here's what the district's position would be, we'd be fine with a motion and second to change the name of the improvements to THF Saltgrass Landing LP. Period.
Okay,
That's-
Well, just-
So it's THF.
It's THF, Sawgrass Landing LP. See, you go. Kathy, right up there.
Yeah, all right.
That's it. Yeah. Yeah. That's what, this gentleman said. So,
And then I guess another motion, again, this is a district position, might be to move in second to exempt the land component of the second property. And then the third motion would be
The name of THC.
THF, Texas Housing Corporation.
THF.
Yeah. Then I guess the third will be move in second about whether the improvements are exempt. Actually, would that be an issue? I guess so, that's before the Airbnb. It's around
I'm just making notes here. The exemption,
It's on the land.
the exemption is on the land, and which is held by,
THF.
where on the picture? The bottom left.
Top left.
B, date and lane.
You know that. Owner.
Thank you. I can see it now.
Okay.
Okay, so,
So the land is not really.
That's what we're going to be. moving.
yeah, as I understand it, there's one entity that, at least from the district's perspective, one entity that encompasses both land and improvements. And the property owner is asserting that both of those, the land and the improvements, should be considered tax exempt. The district has presented evidence that supports and does not disagree with the land being tax exempt, but does believe that the improvements are not tax exempt. Now, the only way to allow that to occur is by having another account created, or having the THF Saltgrass LP get the improvements.
Be taxed on the improvements.
Well, they have to,
Or
the name of the
they-
improvements has to be associated with the THF Saltgrass Landing LP.
Right.
Okay, and that the improvements under that LP, associated with that LP, the contention is that they are not tax exempt. And
So
the,
that's what y'all are approving.
yeah, I'm just running through what I think we're gonna be making some motions and votes on. And that the, although you questioned whether it was technically necessary, but we'll go ahead and make a motion that Texas Housing Foundation, THF which is the owner of the land. The fee simple owner of the land
Owner of fee is
Is-
base, yes.
Payments.
Act
is tax exempt.
exempt, yes.
Okay,
Got it.
if you got it, fine, do it. I'll leave that here to confuse you if you want. Okay, I'm gonna confuse it, so I'm gonna.
You can add it over. Oh, you're gonna find.
Yeah, well. It's always good.
Case ID 2022, yes, 2023, now 27852. If you're listening from the discussion from the property owner's attorney and the district attorney, comments from the appraisal review board attorney, the recommendation of the ARB is that the PHC is the landowner and
BHF.
PHF.
PHF, I'm sorry, the landowner and the other person, that the project owner, PHF software and LP, is the owner of the improvements and they are in the taxable meeting. There is also a suggestion that the name change to include the PHC.
BHF.
PHF.
Okay.
And the last thing that is protected is market value, which came to
So let's get this. All right, so I'm gonna,
So I
Joanne.
I'll second.
all in favor?
Yes.
All of a sudden, you're the chairman.
The only question is whether we can do something.
No, it was explained, the land.
No, they don't.
Okay.
Okay. Can we vote?
Yes,
You don't
okay.
want to say
Did I hear a second?
Yes.
We have a second. All in favor? Anybody opposed? Okay, those. Good.
Who seconded?
All right, so now we do this, the value.
Of the improvements. Yeah.
Is it just market value or is it market equity?
Market and equity.
Okay.
All the same.
Payment will present that.
Yeah, come. What's the open check? Oh, well, it's the and/or.
Yeah.
So,
Ready?
Yeah.
We're still okay.
see it all.
She's got. Whoa.
Where are you finding this information? The other eight data.
They had evidence 1 and 2. Why not?
Okay, are we ready?
Yes, sir.
All right, so this is 27852. Can I tell you where it is? Okay, so this is, last year it had a value certified at $2,921,970. It's an apartment complex, so it's category B1. All of our apartment complexes are on the income value, even if they were not, however. Because this is a low income housing, property, it has to be considered on an income basis. Right? So, the notice value for 2022 is $2,966,800. There's a slight change from last year. There was a change in the tax rate. That's pretty much the only thing that happened year over year. You scroll down, write a few pages, a lot of improvements. So this is where our value came from. The rent rate for every apartment in Aransas County is $11,700. Excuse me, $7 a year. That's per unit. Saltgrass Landing has 50 units. So that's where we get our gross potential income. The allowable stabilized vacancy is 13%. And the apartments are giving 55% expenses here in Aransas County. That's where we get our net operating income, $232,004. The cap rate is 6.06, and it gets loaded with taxes, and that gives you your value. It's pretty straightforward. I will come back to make a note about the subject property in a minute, but that's where the notice value came from. So the next page is showing equity. This is other apartments that are not necessarily in the same area. The only difference between these things is going to be the number of units and possibly the tax rate. But if you look, everything has the exact same lease rate, the same expense rate, the same cap rate. They're the only adjustments that would need to be made to make any comparable like the subject would come in the form of changing the rentable area or the tax rate. So everything is hyper equitable across our county. They're all being treated precisely the same. The Bay of Aransas garden apartments are also low-income housing. So is 50 Oaks, and Rockport Oaks Garden Apartments is not. So if you see, they've all been noticed at the same rate. Okay. What follows after that is a sales ratio report for income properties. Actually, the next page just shows you one more thing. Oh, so I guess it's the last page. There you go. That's where our cap rate came from. That's the cap rate for CoStar for multifamily for Rockport, North Aransas. So the subject is low-income housing. The advice of our council is to settle low-income housing on a lease fee basis, which is where you value the property based on its actuals. So if you go back up to the property value, the income worksheet, that right there. This is not possibly not going to be their net operating income. I would not expect it to be. The whole point of lowering their rent is to depress this number. So to adjust for what should be the difference between these rent controlled properties and market rate apartments, you just settle it on whatever they are. I will tell you from my own experience also, they tend to be slightly less efficient in terms of how they're managed. So their expenses sometimes are kind of high. I have not received anything in terms of actuals from this property last year or this year. I can't do a lease fee evaluation if I do not have their rent rolls. I don't have anything. So they've been treated like any other apartment. I would be happy to settle with them for whatever their actuals show. I don't know what they are. And I guess the representative for the property owner is even here, so I don't know if they have the intention of showing that to us. On the equity grid, the other properties on there that were low income housing properties, they did get settled that same way. They showed us what their rent roll was and what their expenses were. And Bay of Aransas garden apartments, they're not making 185 a year. They're making like 60. I don't remember what it is. 50 Oaks is not at 232. They're at like 140. So, I need them to tell me what that is. I can't speculate what their actuals are. The whole point is to settle on what it really is. They just need to tell us what it is. And that's been communicated.
Okay, right. Does this include, when you're looking at these numbers, the land, since we're taking the land out of the equation?
Yes.
Yeah.
Income valued property considers the land and the building all as one economic unit. So if this property were to be taxed for the improvements value and not the land value, you would take an income derived pool, which is going to do this. Currently, it's $2.9 million, and then abstract the land out. We still have a land value. Let's go back up to the property card.
Yeah.
Just take the land out. Yeah, I think that's going, that, in my opinion, that seems like the gist of what was decided.
Yeah.
Yes.
So the bottom of the property card should give a land value. Oh, there it is. Anyway, so it's 395,580. The assertion is that Texas Housing Foundation should continue to be the owner of this $400,000 property. And then THF partner or THF Telegraph Landing LP should be getting the bill for that. I don't know.
We
We can't recommend that. Can we recommend that? And then you have to figure out how to do it. Or is this something we need to put on hold and come back to?
That's up to y'all.
Judy still?
There's several discretionary things that just haven't happened. We can't, they're currently, as it stands, they're gonna be the only. Hold on a second. Julie, did you say something?
Well, I was not sure if there are questions about whether you should determine the tax code. Is that the question?
No, I think the general question is, should a motion be made to deduct $395,000, which is the land value, from the market value for the subject property, thereby essentially creating the effect of the exemption that's kind of going to be granted? That's the question.
Oh, well, that's really a value issue that it's not a legal issue. Did they want to advise on that?
I would normally say no problem. It's weird though, because the ownership of this PID is the one that we're going to say should.
Yeah, I think the district
It
should be,
depends on how you determine the value. If you determine it that way, if that is the plan, the value attributable to the land, of course, you have to deduct that.
But won't that be deducted when we split them?
Yes.
yes. But I think what the question is, what is the ARB taking up? And if that's the value of the salt grass land and LP improvements,
Yes,
then that would be the value without regard for the land value.
right, which is one of the very top.
Yeah.
That's what I think.
Right.
Okay.
And I would just, I don't know that.
Yeah. Can I just make a suggestion that might simplify it?
Yeah.
The ARB commission. The market value of the project. And then
When it gets split.
That's makes sense.
Yeah,
You know,
and the board, the ARB is already, I'm in agreement with that.
And just make sure
Yeah.
that's.
Okay.
Right. So we can make a motion on that, the total assessed value, and then the district will divide it out.
But you need to say what the land is and say what the improvement is.
Right, okay.
I will just say once again, that doesn't change anything, but for the record, I want to be clear. As it stands, this is going to be the only low-income housing apartment in the county that is not settled on a lease basis.
And that's,
They haven't told us.
and that's their problem.
They could have and should have.
And this one, oh,
So,
So
so again, I would suggest the motion to, three numbers. Total.
yeah.
The improvement,
Yeah,
the land.
and the words that say, direct the district to do the appropriate split. Of those,
We're
of
going
the
to
lands.
raise the values to the 257.
Should we keep the
We're gonna
district
reduce
value?
No,
and
we
then-
just, you do the total, Judy, and then you direct the district, I mean, I'm saying.
You just list all three of them.
Just one package. With three components.
On case ID 2022.
We agree.
Three numbers.
you're probably about that, before the order is.
Yes.
The improvement is going to be 257.
Right.
The land is going to be, the total. Yeah.
Correct.
Yeah.
Yes.
Okay. In case ID 2022, 2023. Count 27852. Casing, to the ARB, you value the improvements on this property to $2,571,220. The land value at $295,580. The total assessed value of $2,966,800. And the district will make the appropriate distribution from the land. And the
Okay, yes.
I second. I second.
I don't,
No, all we're doing, I think what our intent was, and she did offer the total value. She called it assessed value. And that was the total value. And she also offered two other numbers. One was an improvement value and one was a land value. And that it adds to the total value and is more of an instruction to the district on how the ARB is directing or requesting that the total be split between land and improvement. That makes sense?
okay. I think so, but I just don't want the order to be confusing. I don't want the order to, for example, say, here's the land value, just the improved value is this, but the chief appraiser then shall allocate, and the chief appraiser's allocation is different, value for the land.
Yeah, we'll keep it the same, and I raise my right hand and profess that I will be, since I have to sign the bloody order, that I will verify that is in fact correct and unambiguous.
Would you think it'd be appropriate to run the proposed order by ARB council before it's signed?
That's fine, we can do that.
Okay.
So sometime tomorrow, I'll send you a copy, follow up with a quick follow or something, and we'll go from there.
Thank you.
The property owner presented no evidence on market or equity. And in the case of this being an income, an appraisal using the income method, I don't think we have
Yeah.
any way to make the distinction between market and equity.
Well, I think there's no evidence other than the appraisal district and
The property owner was very different about any information on this aspect.
How about,
I think we just say market.
this is the district position. How about if the ARB moves and second, a motion that the owner's equal and uniform protest is denied?
Fine.
What do you think?
and the value.
Yes. Yes. So does she have to amend?
No, she just makes another
Oh,
motion.
another one.
If the,
Uniform and equal.
the owner's equal and uniform protest is hereby denied. That's the district's position.
Equal and uniform is equity. Okay. But say that is fine.
Right, in the motion. Now, I need 122. It's 106.
The bottom of page three.
Three.
The bottom of page three.
Not three, not one. With three, wherever three is.
Here.
Okay. It's like 2022, there's 2023, now 3785. The recommendation, district that the property owners. Trust board, uniform, uniform.
I think our position was that there would be a motion in second that the owner's equal and uniform protest is denied.
Yes, and there's no change.
Right, the request is that the owners request for each law uniform. Denied.
Second.
All in favor?
Aye.
Anybody opposed? Okay, that carries. So we've handled equity and we've handled market. Just leave it here for the time being.
Oh, he wants. What, yeah.
Okay, and Judy, I have, in addition to the determination order that I'll send to you tomorrow to peruse, I also have a copy of the letter that will be sent addressing the denial of late protests for the tax years 2019, 20, and 21. I'll send you a copy of that letter for you to just double check and make sure that we're okay. You know, we don't need to be any more verbose.
I believe that his order. Project would not be heard, so I think it would be appropriate to go ahead and.
Can you do that?
Yeah, I didn't have.
Okay, we didn't really vote on it like we would a hearing. We voted on it like we would hear a letter. And so what?
Yes.
Not walking away.
Thank you very much.
Oh, thanks so much for your time.
Yeah, thank you so much.
Bye-bye.
Bye now.
Wow.
I'm trying to think.
I'll do tonight.
Yes,
Yes,
trash.
and don't throw that
He
away.
didn't take his,
So if you can get me a copy and. Get this out.
Did you not close the meeting?
It was
No,
Can you do that?
yeah, guys, I need a motion to.
oh, I moved that we adjourn.
I second.